We are time, and I call this session of the Public Service Commission to order. Assistant Secretary Elise, are there any changes to the final agenda?
Good morning. There are no changes to the agenda this morning.
Thank you. So with that, we will begin with the first item for discussion, which is item 201, cases 14M0094 et al., as they relate to the petition filed by the New York State Research and Development Authority regarding data and reporting, presented by Ted Kelly, Assistant Counsel. Peggy Neville, Deputy Director, Office of Clean Energy, and Bruce Alch, Chief Retail Access and Economic Development, are available for questions. Ted, please begin.
Thank you. Good morning, Chair Rhodes and Commissioners. This item is a proposed order regarding a petition filed by the New York State Energy Research and Development Authority, or NYSERDA, regarding access to data and legacy reporting. Part of NYSERDA's role as the state's Energy Research and Development Authority is to conduct studies and evaluations related to the state's clean energy progress and initiatives. This is laid out in NYSERDA's authorizing statute, the Public Authorities Law, as well as in the state energy law. Furthermore, the Commission has directed NYSERDA to perform these sorts of activities in various orders, including in the authorization of the Clean Energy Fund. NYSERDA has already conducted a number of these studies over its history. In many cases, these studies require data collected by the state's gas and electric utilities regarding customer usage. Needed utility data may relate to customers who are participating in clean energy programs with NYSERDA or the utilities, or may relate to customers who have not participated in clean energy programs, who I'll refer to as non-participants. For example, in 2015, NYSERDA worked with the utilities and received the necessary data to conduct the residential baseline study. Baseline studies use current energy usage data, including the prevalence of certain energy technology of clean energy technologies or measures, to determine a baseline level that can later be used for comparison of progress. Baseline studies and similar tools are especially important for REV and the Clean Energy Fund because those initiatives aim to increase clean energy deployment through market development strategies rather than simply through resource acquisition strategies. Baseline studies require both participant data and non-participant data, with the non-participants acting essentially similar to a control group. In addition, because the study is looking at granular by-customer data, aggregated data is not sufficient, individualized data is needed. The residential baseline study and other studies like it were conducted in compliance with guidance issued by staff at the direction of the Commission, and the guidance was regarding data protection and privacy. In addition, NYSERDA and the utilities negotiated data security agreements for those studies. More recently, the utilities have expressed reluctance to continue to provide non-participant data to NYSERDA without specific Commission authorization and guidance. As such, NYSERDA filed the petition, which requested that the Commission authorize NYSERDA to receive non-participant data for two specific use cases. First, to assess performance and effectiveness of clean energy programs and policies, including through potential baseline and market characterization studies, as well as other evaluation, measurement, and verification activities, and two, for implementation of NYSERDA's Clean Energy Fund portfolios. NYSERDA also requested that the Commission create a process for these data requests, as well as determining the appropriate data security and privacy protections. The draft order grants NYSERDA's request with respect to the first use case, conducting studies and other evaluation activities, but denies the request with respect to the second use case for implementation of the CEF portfolios. The first use case is consistent with the work that NYSERDA has been doing for years and with its responsibilities under the law and Commission orders. It is also consistent with the utility's own use of data for studies and evaluation purposes, as well as the utility's sharing of data with their own contractors. The second use case is overly broad and lacks the necessary specificity. The petition does not explain what specific activities might fall into that category, nor how those activities would be consistent with current or past practice and with consumer privacy interests. The data order creates a process by which NYSERDA will publicly file its requests for data. The utilities will then respond by either agreeing to fill the request and providing a timeline, or by objecting to the request if they believe that it is not consistent with this order or is overly burdensome. And where the utility objects, department staff will determine whether the request is consistent with this order. The draft order also creates a process for the development of a standard memorandum of understanding between NYSERDA and the utilities governing these transfers of data, which will include data security and privacy provisions. The utilities are required to propose a memorandum of understanding consistent with past agreements between the utilities and NYSERDA. Those past agreements include strong data security protections, as well as cybersecurity insurance requirements. The utilities may propose new additional protections with explanations for why those new protections should be added. NYSERDA and the utilities will then negotiate a final agreement with staff available to arbitrate if they are unable to come to an agreement. This order will allow NYSERDA to conduct important evaluation activities, such as the commercial baseline study, to ensure the state's clean energy programs are successful. NYSERDA's petition also requests that the Commission modify the reporting requirements of two programs that have program periods that have ended: the Systems Benefits Charge, or SBC 3 program, and the SBC 4 program. These programs stopped accepting new applicants a number of years ago. However, some of the contracts signed under those programs involved performance payments over the life of a contract. Therefore, payments from those programs have continued, and reporting has accordingly continued. At this point, both programs have very few outstanding payments. Therefore, NYSERDA requests that the remaining reporting be limited to a final report for SBC 3 and annual reports for SBC 4, followed by a final report when SBC 4 has completed all payments. The draft order grants the request. With respect to SBC 3, it directs an interim final report this year, followed with an updated final report when all payments are complete. With respect to SBC 4, it directs annual reports, followed by a final report when all payments are complete. That concludes my presentation, and Peggy, Bruce, and I are available for questions.
Thank you, Ted. It's foundationally important that we ensure that the programs that we approve do in fact work. And specifically, this means being able to tell if we're making a difference. And that requires data. I find this report assures that data in a way that's careful and appropriate, which is necessary given that we're talking about data and therefore about privacy and security. And I also find that the other items beyond the larger access to data question are well handled. I'm going to be in favor of this item. Commissioner Sayre.
I'm pleased to support this item. In general, I support the proposition that if you can't measure something, you can't improve it effectively. As Chair Rhodes said, we have to keep improving these programs. Nobody can expect them to be perfect from the outset. And if we're going to improve them, we have to measure them. This item allows us, through NYSERDA, to look at the success and less than success of our clean energy programs. And it provides, in my view, as the chair said, an appropriate level of protection of the consumer data.
Commissioner Berman.
Thank you. I'm going to be dissenting without prejudice for NYSERDA to refile. I do want to discuss my rationale because I do think it's important for thoughtful consideration, even if my dissent doesn't convince others. I am very pleased with the work that DPS staff did to take what was a petition that had far-reaching implications and narrow it, though I don't think it goes far enough. I do want it without prejudice, though, because I do think a careful evaluation of access to that data is important, and there may be an opportunity for, with more information and more collaboration with other stakeholders, I could feel comfortable with that. My concerns relate really to several things. The first, I'd like to ask Ted, you to explain the UER, the status of that, and how this relates or not to this item.
Absolutely. So last year, the Commission authorized the Utility Energy Registry, which is being developed by NYSERDA with the participation of the utilities. The Utility Energy Registry collects aggregated customer usage data, generally aggregated at the municipal level and by customer type, residential, for example, commercial, and provides that, and will provide that data in an open website where anybody can search it, review it, and use it to do energy planning, do energy targeting, and so on. The UER is currently under development at NYSERDA. All of the utilities have provided NYSERDA with the necessary data to get the UER up and running, and my understanding is that currently NYSERDA is open to by email while they currently finalize the open access website, which they expect to have up and running, I believe, in the second or third quarter of this year.
Okay. So my concern relates really to this is a policy shift in that we as a commission are looking at giving potentially broad data access to non-participants of NYSERDA. And while we have done it, NYSERDA has done it with utilities in limited cases on a case-by-case basis, looking at the MOUs, et cetera. As it relates to now giving a 3-year MOU and approval, I am concerned about that. So what I'd like to see, if NYSERDA was going to be putting in a revised petition for consideration, which is why my dissent will be without prejudice, I would really like to see the MOU template specifically as to this, because I do think it will, while it may mirror other MOUs that have been done, I do think to the extent that the Commission itself would be able to drill down and also have potential comments from stakeholders on that MOU, I do think it would be important and helpful, especially as it is a broad MOU to not one specific study. So it may be important for us to have some other caveats in there. The second is the MOU itself is worked through only with, at this point, staff and the utilities. Without, while taking into consideration some of what the Commission order says, it does give wide latitude for that MOU or revisions to that latitude without Commission direct oversight, and that concerns me. And it's also being done without, in this case, any external consumer advocates or other stakeholders having weighed in, except for CPA. And so I do appreciate Consumer Power Advocates' comments, their concerns, and I would imagine that there would be other concerns as we go down the road. Now, I do understand that the second part, the phase 2, I guess in my mind it is looking at it outside of the first use cases. We would hope that there would be more consumer engagement and advocacy. Frankly, I do think it is incumbent upon anyone who is submitting a petition that touches upon and directly touches upon consumers for that petitioner to make sure that there is direct outreach to consumer advocates or others who may be affected by this, and to seek out that and to let us know if there is any support or opposition on that. My other issue is really related to, I would have liked to see in the petition the actual studies expected to be done. That would give us and probably give other stakeholders more information on exactly what is planned. It's a 3-year plan. I think we should know ahead of time what those studies are going to be, are expected to be in whole. There's a lot right now that is being proposed potentially in the budget, and to the extent that some of the things that may or may not come out of that I think would fall into that, and I'd like to make sure that the Commission itself is fully engaged on that, and it's not left to another potential new or old entity to look at that, but rather this is under the Commission's umbrella, so it's important for us to know exactly how those studies may be done, and to the extent that NYSERDA is engaging with any sister agencies, including ours, in those studies. We should know about that ahead of time, and that should be part of the revised petition that explains that in more detail. The other issue I have is I really want to understand, and the petition was lacking in this, in how NYSERDA plans to keep confidential this data. I do understand that they would be following normal protocols in confidentiality and working through that. But to the extent that internally, I'd like to see exactly what the process is, especially even if they have normal processes now, but especially as it relates to this new access to data that would be coming in. It should really be limited only to those who are participating in the gathering of information and the analysis for the study. And we should make sure that there is clear guidance given internally in the fact that this information cannot be taken in any way and applied externally or internally for other uses, and so that it really is the use for this study or these studies that may be done. That also goes to how it will be in terms of being shared potentially with other sister agencies or any external consultants. And while we address it a little bit, we really, I think, need to make very clear that the access to this data is very limited to helping in that analysis and not to be used even inadvertently in others without some clear guidance from the Commission. For me, I would also like to see specifically the petition, especially since the current one was so broad in trying to capture it for many uses. I'd like to see what the actual steps will be to limit the need for this. There is, I believe, in a focus on encouraging them to use it, to use UER before they go to this, but I'd like to see exactly what that process is, what that analysis is intended, and rather than encouraging, UER is what should be utilized first and foremost, and any alternative need outside of that needs to really be looked at. But my concern is we've spent a lot of time on the UER, and it's also something that is evolving. And I'd like to make sure that the UER process is one that evolves appropriately and not this in many ways can be seen as, well, we don't need to do the UER because we have access to that data from other means doing a study. And that's why it's important for me to make sure that we're linking the clear understanding of what studies it would fall under, as well as looking at what we're doing to the UER if there needs to be refinement, as has been expected, that would be an evolving process. The UER discloses the information in an aggregate fashion, if I'm correct, and it's publicly available and will apparently in June be available via website for all. And so that really, at that point, that gives everyone the ability to see the data and to have that information, and it's a fairness perspective that everyone has it. They can look at it. They can understand where some of the penetration issues are. They maybe could do some targeting of the information in the aggregate fashion, but not specifically targeting specific customers. My concern relates to, in this, NYSERDA and any of its consultants or sister agencies, they're the only ones that have this data from the utilities. And therefore, they really sort of have an ability to have more information than those through the UER process. And while we are very mindful that they should not be using this for anything other than the studies, to the extent that it is important that this gets into exactly what they can do with that information and the analysis of that. And that's missing in the petition. So, for example, in the UER process, everyone would have access to that information. They may be able to see X county has certain number of things. They can then target or market to the county itself in that fashion. Here, it might be taken to utilize this and to target maybe not the specific customers, but to understand that this is going to X county. We should target the entire county that way. And those are the types of things that I want to make sure we have clear understanding from NYSERDA and from the folks in the guidance on that, and look carefully at that. And that any question as it relates to we're going to use this outside of that study for X really needs to be addressed by the commission itself rather than left for discussion with staff and the NYSERDA folks. My other concern is the draft order really focuses very much on generic legal language, legislation, etc., to support doing this in generic sections of the law. The only time we go beyond citing to the generic sections of the law for our ability to do this is when we talk about the guidance document that is currently existing. That guidance document, the most current one, was not approved by the Commission as itself, but the guidance document was worked on with staff and the now defunct Clean Energy Advisory Council. And so for me, when I look at this and see that the guidance is going to be revised to reflect that, while it kind of will reflect and it should reflect what the order says, what it does is it opens up a conundrum in that we are not looking at the specific guidance language that will actually be inserted, and we are missing that stakeholder outreach that was there in some fashion with the Clean Energy Advisory Council. So I just put that out as concern for me because I do pause whenever I see a draft order where we're really relying on just generic sections of the law rather than specifically. And in fact, in the guidance document and in many of our orders, we have focused very carefully on the protection of access to customer data. So this is really something that gives me great pause. The other issue I have is really relating to the legacy reporting. So I think that NYSERDA, in bringing up an issue of the legacy reporting and looking at it and saying that they want some leeway in submitting this report annually and semi-annually for the different reports. My concern is that it again misses the mark. Yes, it is important for us to have timely reporting. We can discuss whether it's annually, semi-annually, monthly, whatever it happens to be. The issue really isn't, to me, the how many times someone reports. The issue is that it's timely and that it's actually comprehensible and usable for everyone. And what I'd like to see, which I've said before, what I really would like to see is more of a collaborative effort on looking at the reporting structures that come, looking at all of the different subsets of information that come from other reporting that we get, and really work on trying to make sure that we're giving timely, accurate, factual information in a way that people can really grab onto, not just those, wonky folks or others who, are looking at it day in and day out, but really having people really come away with real understanding and usefulness to actually being able to read the reports and decipher the reports without having to really struggle through that. It's something that really is important to me, and I think we really should be working towards looking at doing that sooner rather than later. I do think that my concerns really can be alleviated with more thought and with some more input. I am very hopeful that we can get to a more if not in this petition, but in others, where there is a lot more granular information. There is really more specific information that helps us to really understand it. But for me, it's lacking in the details. Some of these studies, we may not even know what they're going to be because of the ongoing discussion on what may come out through the legislative process. And therefore, it's important for me that we take a pause and give an indication to NYSERDA on what we're looking for and also get some more outreach from those stakeholders who may be interested in this, and also help us to formulate a better policy and being very clear on the information is important, and again, how this doesn't conflict with the UER. And I'd like to see, even in the revised petition, a indication of how they plan to utilize the UER in a more robust way, and how this will not chill any of the ongoing activities as it relates to that, and would help me feel more comfortable. But right now I feel that this is not the right time for this, and we need to really be much more careful, because it is access to customer data, non-participant customer data in NYSERDA programs. So that's my food for thought, and that's why I really fall on the dissenting without prejudice to resubmit. So, thank you.
Thank you very much. Commissioner DeLisi?
Thank you, Mr. Chairman. I think this is a reasonable request. I recognize NYSERDA as a legitimate entity in our efforts towards clean energy, and I think that with strong data security, we're in a better position to share things and to measure the things that we share, and use those measurements to make predictions that will get it closer to our common goal of clean energy. So I'll be voting yes.
Thank you very much. With that, I'll proceed to call for a vote. My own vote is in favor of the recommendation to grant the petition with modifications as discussed. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
I dissent without prejudice.
Commissioner Lisi?
Aye.
The item is approved and the recommendation is adopted. We'll now move to the second item for discussion, which is item 301, case 18E0766, which is the petition of the New York Power Authority and the Port Authority of New York and New Jersey for a declaratory ruling, presented again by Ted Kelly, Assistant Counsel. Marco Padula, Acting Director, Markets and Innovation, is available for questions. Ted, please begin.
Thank you. This item is a proposed declaratory ruling regarding a petition filed by the Port Authority of New York and New Jersey and the New York Power Authority. The petition relates to the Port Authority's interest in building distributed solar generation at JFK Airport. NYPA joins the petition as it will assist the Port Authority in developing solar. The Port Authority explains that, as part of its clean energy goals, it is interested in building a 5-megawatt solar photovoltaic system as a community distributed generation project. The CDG project will be focused on serving low and moderate income residents in the environmental justice areas surrounding JFK Airport. The CDG project would be compensated under the value stack compensation method authorized by the Commission in the Value of Distributed Energy Resources proceeding. The Port Authority is interested in building 5 megawatts or more of additional solar besides the CDG project to serve its own energy needs at JFK. This additional solar would be separately interconnected from the CDG project and would be designed only for self-supply, that is, to serve the energy usage by the various parts of JFK Airport, rather than to inject energy into the utility system. The Port Authority explains that Con Edison has indicated that this arrangement would not be permissible under current rules because Con Edison believes it would violate the 5 megawatt rated capacity cap. The 5 megawatt cap, set by the Commission, is an eligibility limit for value stack compensation. Generation larger than 5 megawatts is not eligible for value stack compensation and therefore is also not eligible to be a community distributed generation project. To determine whether multiple generation resources should be considered together for purposes of the cap, the Commission established a 3-factor test. Projects receiving value stack compensation are aggregated for the purpose of the test unless they are 1. Separately interconnected and metered, 2. Operationally separate, and 3. Sited on different parcels of land. The Port Authority explains that Con Edison has stated that it interprets the 3-factor test as applying to all generation on a parcel, even if only some of the generation is intended to receive value stack compensation. Therefore, it would apply the 3-factor test to the 5 megawatt CDG project and the additional self-supply generation. It would then find that, while the projects would be separately interconnected and metered and operationally separate, they would both be sited on the same parcel, as JFK is on one large parcel of land, and would therefore fail the test. Thus, the 5 megawatt CDG project would not be eligible for value stack compensation or to be a CDG project. In its petition, the Port Authority and NYPA argue that Con Edison is incorrectly interpreting past Commission orders and its tariff language. They argue that the 5 megawatt cap and the 3-factor test should not be applied when only one generator is intended for value stack compensation and the other is intended solely for self-supply. Consistent with declaratory ruling regulations, Con Edison received notice of the petition and filed a response. Con Edison argues that its original interpretation is correct and that a contrary interpretation could allow large-scale generation projects to inappropriately receive value stack compensation by subdividing their projects. The proposed ruling finds that the Port Authority and NYPA are correct and grants the petition. It finds that the intent of the 5 megawatt cap and the 3-factor test are to ensure that a large project is not split into multiple smaller projects to receive value stack compensation, since large projects should appropriately go to the wholesale market for compensation rather than the value stack. This also helps manage the potential non-participant impacts of value stack compensation. However, applying the cap where only one project is designed to receive the value stack and the other is designed for the self-supply of a large energy user is inconsistent with both the intent and the language of the 5 megawatt cap and the 3-factor test. It would inappropriately limit the ability of large customers to manage their own energy usage. In this case, and in similar cases, one large project is not being inappropriately divided. Rather, this is a situation where multiple smaller projects with separate purposes happen to be on the same large parcel of land. For these reasons, the draft ruling grants the petition and finds that the rated capacity of projects seeking value stack or net metered compensation should be aggregated to determine whether the rated capacity limit and the 3-factor test are satisfied. However, the rated capacity of projects used solely for serving on-site load and not seeking compensation under value stack or net metering should not be counted towards the rated capacity limit, nor should the 3-factor test be applied in those cases. That concludes my presentation, and Marco and I are available for questions.
Thank you, Ted. I find this ruling to be clear and helpful and narrow clarification of our intent, of the intent, and of the intended application of our language. I'm going to be in favor of this item. Commissioner Sayre.
This is a simple but important interpretation of our 5 megawatt cap in the value stack compensation process. We never, well, I'd better say I never intended through my vote on the value stack to exclude a small project from value stack compensation just because a large customer has a bunch of other generation in the same area that won't ever hit the network, as intended solely for self-supply. This item takes care of that situation clearly and simply, and it's even more compelling because the 5 megawatt project that will hit the network is community DG that's intended to benefit low and moderate income consumers. So I'm pleased to support the item.
Thank you. Commissioner Berman.
Thank you. Thank you, staff, for your hard work on this. Can you explain, one of the concerns I have is the wholesale market, and whether this intrudes upon the wholesale market that would be going through the ISO process rather than here. Can you explain that?
Yeah, so the reason that a project like this one or like another project that could be built under this declaratory ruling would not be an inappropriate avoidance of the wholesale market is because the primary project is intended for self-supply, and customers always have the option of building large generation for self-supply even beyond the 5 megawatt cap without going to the wholesale, without having to interconnect or be involved with the wholesale market. They can still be direct customers of a distribution utility while having that large generator for self-supply. So in a case where the generation besides value stack generation is only for self-supply, the wholesale market wouldn't be appropriate in any case.
So you see this order as being limited only to the new interpretation that's different from Con Ed. In this case, if it would not apply to the wholesale market.
Right. If it were instead of self-supply, a second large injecting project, or that would present a different scenario, and that wouldn't be covered by this ruling. And it wouldn't be covered by this ruling.
So what if NYPA and the Port Authority do something that would now, if not but for this ruling, included something that then would make it a wholesale market situation? How do we get around that?
So
how do we address that?
Right. In that case, when they would have to submit, for any project like this, they would have to submit an interconnection application with Con Edison. And because this ruling on Con Edison's tariff only changes their interpretation for a self-supply case, it's my expectation that if there was a non-self-supply project, Con Edison would reject the interconnection application, or potentially not reject the application, but warn the Port Authority that proceeding with it would limit their ability to receive value stack compensation.
Okay, thank you. That's very helpful. And to the extent that NYPA has had ongoing focus on increasing its jurisdictional reach, how do you see this item applying to that issue?
Sure. So this item is really within NYPA's core existing jurisdiction in that it's supporting one of its own customers. As Port Authority is a partial NYPA customer, including partially for its JFK load, supporting one of its own customers building on-site energy management tools, including renewables, energy efficiency, and so on. And that's really a kind of a core and fairly traditional part of NYPA's jurisdiction.
Okay. And why NYPA working with the Port Authority other than a non-government market participant?
Yeah, so again, it's because it's their ability to support one of their own customers in this case, but there will also be non-government businesses involved in this, as neither NYPA nor the Port Authority will be the ones who actually build the solar. They'll go out to solicit private businesses to put in bids to build the solar.
Okay. Now, NYPA, the Port Authority, NYPA is not the only. The Port Authority is not just a NYPA customer. They also are a Con Ed customer, if I'm correct, right?
That's my understanding, yes.
Right. So it could be something where we could be looking at Con Ed being involved potentially as it relates to...
Certainly they'd be involved with the interconnection process, as the local utility always will be for a project like this. Building the solar, that's not within Con Ed's business either.
Okay, it's food for thought. NYPA and the Port Authority boards, what's their approval process on this and the actual projects that they would be doing?
So I'm not familiar with their regulations. My understanding is that generally boards approve capital plans and capital projects, and I would expect that this would certainly for the Port Authority be a capital project. So it would likely go before the board for that reason, but I'm not very specifically familiar with the regulations, so I can't speak to the exact details.
Okay. And how do we follow up with the CDG portion of it? Obviously, that's something that as a commission as a whole, we've been very focused on. How do we make sure that that actually this intended item to help spur that actually happens, and what's the follow-up to make sure that we're looking at the customers benefiting from it rather than just NYPA and the Port Authority.
So we're in regular and close contact with the interconnection teams at the various utilities and the distributed generation teams at those utilities. So I expect that through our continued contact with Con Ed's interconnection team, we'll keep an eye out for when these projects file their formal interconnection applications, and then we'll keep an eye on them through that to ensure that they're acting in compliance with expectations and commission and what the commission said.
Okay. So I struggled with this item because for me, I did at first blush and continue to understand Con Ed's interpretation, and I do look carefully at the fact that the utility itself interpreted it this way and is important in looking at that. I do understand that there may be other interpretations, and so it's not that I see Con Ed right and the staff wrong, or the staff right and Con Ed wrong. I do see that there's potential interpretation issue that needs to be resolved, and obviously the Commission is the one to resolve that. The pause I have in that is that I'm not fully convinced that this was the original interpretation or originally thought of as an issue. I can't really find anywhere where this potentially unique situation came up and was thought through. So to the extent that we have the three-factor test, and at first blush it seems like they don't meet it for doing it this way, I would agree that Con Ed was right to see that interpretation the way they did, though I could also see interpreting it differently potentially. The pause I have is, and I've raised this issue before in other declaratory rulings, is when we get a declaratory ruling petition, it generally is not, and it does not have to be SAPID, and it generally is not and does not have to be issued by the Secretary for comments. However, this really affects not just NYPA and the Port Authority and its project. It affects potentially, it has statewide implication, even to the fact that we have an ongoing value stack proceeding where we're looking at potentially tweaks to it, or looking at what folks are seeing and how it works. For me, I am concerned that, especially because this petition was filed in December with a very short window, that folks may not have had an opportunity to or saw a need to weigh in on something that was a single project with NYPA and the Port Authority and in Con Ed's territory. So, but it may have actually great value to see, and actually the interpretation from the statewide implications may actually have great support for staff and NYPA and Port Authority, or it may not. Without that information, I'm left concerned that I don't have the full information, or I was not giving enough attention to others who potentially could weigh in. I do think that we need to look at that. I do understand that we can do it, but it doesn't mean we should do it that way. I am going to vote no on this item because I think that threshold issue is important enough for us to take into consideration, and also because I'm not fully convinced that Con Ed's interpretation is wrong without more information from others who may weigh in. With that being said, I do think that staff did a good job, and I do really want to focus on the results outcome from this, and also to see that we may need to look to teeing it up on a statewide implication to see if this is something that is concerning or not for others. And I think that would be important for us to do that. So thank you.
Thank you very much. Commissioner Alisi.
Thank you, Mr. Chairman. I'm going to support this. It is a unique situation, at least as we're seeing this for the first time. But I think from my viewpoint, the separate generation, or at least the end goal, is to provide self-supply on the one hand and community generation on the other hand. And those are clearly separated, in my viewpoint, at least as far as what the request is. And I can't overlook the benefit of taking advantage of using the solar aspect to provide more clean energy down there. And it's a reliable energy that I think will help the entire operation. So I'm going to support it. It is unique, but I'll support it and maybe see more of this down the road.
Thank you very much. So with that, I will proceed to call for a vote. My own vote is in favor of the recommendation to grant the petition as discussed. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
No.
Commissioner Alisi?
Aye.
The item is approved and the recommendation is adopted. We will move to the third item for discussion, item 302, case 18E0503, which is the petition of Utica Center for Development, Inc., for a waiver to allow master metering, presented by Craig Carroll, Utility Analyst 2, Office of Consumer Services. Bruce Alch, Chief Retail Access and Economic Development, and Steve Kramer, Assistant Counsel, are available for questions. Craig, please begin.
Good morning, Chair Rhodes and Commissioners. The item before you is a petition for waiver of the individual metering requirements found in Opinion Number 76-17 and 16 NYCRR Part 96. Generally, similar petitions are listed as consent items on the Commission's agenda. From time to time, however, an item that is unique or has received notable public interest may be presented. Here, the Commission will act on a waiver request to its regulations that will help allow the owner to facilitate many services to veterans. The Commission's rules and regulations require that units in new or renovated multifamily residential buildings be equipped with its own meter in order to promote energy conservation by providing the residents with a price signal, except where buildings meet the definition of assisted living facility or senior living facility as provided in Part 96. These types of buildings may still be master metered. The owner in this case, Utica Center for Development Incorporated, is renovating the upper 2 floors of its Veteran Outreach Center to create 18 residential units for homeless veterans or for veterans with and their families. Utica Center requests a waiver of the individual metering requirements described above to better serve this resident population. The owner states that the building is designed to provide services to veterans that encourage self-reliance, including case management, assistance with VA benefits, assistance for employment, legal aid, food, and other supportive services. The owner also explains that residents will be transient and that the living arrangements are otherwise distinguishable from a typical apartment where the Commission's policies would otherwise require individual metering. In light of these circumstances, installation of individual meters, either direct or through submetering, would not advance the Commission's policies that new living units be individually metered, and in this case would otherwise reduce the resources available to Utica Center to assist homeless veterans in obtaining shelter and critically needed services. Staff has verified the owner's claims and recommends that the petition be approved. That concludes my presentation, and we are available for questions.
Thank you, Craig. This is a thoughtful and sensible and helpful decision. I know we issue this kind of order regularly and that we don't always present this and discuss it. So I welcome both the general fact that this gives us a little glimpse into the kind of work that goes on at the department and at the staff on a regular basis. And I also welcome the specifics of this recommended order, and I'm going to be voting in favor of it. Commissioner Sayre.
This is a great example of why it's important for the Commission to keep its eye on overall policy goals and objectives and be prepared to waive restrictive regulatory requirements where they simply don't make sense. This particular waiver request is necessary to provide benefits to homeless veterans and their families, and I enthusiastically support it.
Thank you. Commissioner Berman.
Thank you. I am going to be voting for it. I think it's a really important item. I'm glad that it's highlighted. The only questions that I have are really, and I do want to comment, the order itself states that the waiver is expressly conditioned on the continued use of the building as a residence for the provision of transitional housing for homeless veterans, and the waiver shall be terminated if the building is put to a different use, which is important because it makes sure that that continues. Since the first opinion 76-17, where the Commission determined that individual meeting requirements could be waived under certain circumstances, and we have, since that time, had several of these, a fair number of them, whether it's homeless residence for veterans or college dormitory and a couple of other things for those folks, facilities for Department of Health. The question I have is, how many of them and how many of those, and this isn't for now, I don't know that you'd know it, how many of those have remained in the status based on the waiver, and the ones that have not remained in that status, have we dealt with terminating the waiver?
Off the top of my head, we'd have to check, but
Right.
to my recollection, we've never really had any of those convert. It's a lot of assisted living facilities, nursing home type operations, and they continue. But
Right. That's my impression too. So I only highlight it because it does show some of the longevity of these, and I think it's important to highlight that as well. But it is also a note to remind folks that the waiver is contingent upon them remaining as such. So I think it is important for us to focus on that.
so because of that requirement, we're engaging with the utility as a partner, so they would keep us,
Right.
we expect that they would alert us in the
Yeah.
first instance that
That's
there's a
great.
conversion.
So thank you. That really makes it sufficient for me and important. So I think I'm very supportive of the item. So thank you.
Thank you. Commissioner Lisi.
Thank you, Mr. Chairman. I'm going to support this. I think, first of all, it's a noble effort to help our homeless veterans, but to require individual metering to me seems impractical, at the very least, because the nature of this population of people who have served our country is that they're transient. So to have individual meters in all of the units, I think, just doesn't make any sense. This gives us an opportunity to help people that are indirectly to help those that are helping others. So I'm going to support it.
Thank you very much. So with that, we will proceed to vote. I will proceed to call for a vote. My vote is in favor of the recommendation to grant the waiver as discussed. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
Aye.
Commissioner Lisi? The item is approved and the recommendation is adopted. We will now move to the consent agenda. Do any commissioners wish to comment on or recuse from voting on any items on the consent agenda? Commissioner Sayre?
No.
Commissioner Berman?
I will be. I have 4 items that I'll be voting differently than the consent agenda. Item 164, I will be concurring. Just make sure I have the right number. Item 261, I'll be voting no, consistent with my voting record. Item 371, I'll be concurring. And item 561, for the fifth time, no.
Thank you very much. So my vote is in favor of the recommendations on the consent agenda. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman, with those annotations, I suppose, how do you vote?
Yes.
Commissioner Lisi, how do you vote? Aye. The items are approved and the recommendations are adopted. Assistant Secretary Aisi, is there anything further to come before us today?
There is nothing further to come before you today, and the next session of the Commission will be held on February 7th in Albany.
Thank you very much. So before we adjourn, for everybody who's paying attention to this session, a reminder, we've got a storm coming. We've got a lot of snow or nasty wintry mix, and then we've got a very deep freeze. Be careful and be prepared. Thank you very much.